Good afternoon and welcome to the first of two March webinars with the SILA Foundation. Today is Background Check Industry Trends 2026 Updates. My name is Julie Mendel and I'm the Education Trustee for the SILA Foundation. Before introducing today's speakers, I have just a few housekeeping items for everyone. This webinar is 1 hour in length and is being recorded. We would appreciate you putting your questions into the chat box. We will be monitoring those and posing the questions to the speakers on your behalf. And we will address as many questions as we can in the time we have available. Within the next week, you will receive a link to the recording and a copy of the presentation, as well as a post-webinar survey that we would appreciate you completing. So a little about today's presentation. Background screening practices continues to be one of the most litigated and legislated topics facing employers and businesses, with multifaceted compliance obstacles such as Federal Fair Credit Reporting Act practices, state consumer reporting laws, ban-the-box legislation, EEOC considerations on criminal history, and the use of credit report restrictions. Maintaining risk-averse practices measured against industry practices is more important than ever. To help ensure everyone engages in practices that protect themselves and the industry as a whole, and to build off the trends and data collected through SILA surveys going back as far as 2016, the SILA SACS Background Investigations Task Group conducted another background investigation survey to anonymously gather data about the background screening practices of carriers, agencies, TPAs, broker-dealers, and other similar parties. These results were collected at the close of 2025. Today, we're going to learn about those survey responses so that we can use this information for best practices, improvements, and for general historical trending purposes. We have two speakers today to continue our annual discussion on this ever-changing landscape. Greg Kirsch, the Chief Operating and Compliance Officer of Applicant Insight No More Forms, is an industry-recognized expert in background screening solutions in compliance with the Fair Credit Reporting Act in the employment, contractor, and volunteer screening context. He manages large compliance-driven programs and regularly consults with many of the most visible companies and carriers in the country to develop screening solutions that are cost-effective, compliant, and address corporate goals and regulatory requirements. Greg currently chairs the SILA Agency Carrier Background Investigations Task Group. He holds advanced SCRA certification through the PDSA and is a graduate of the Westchester University of Pennsylvania. Matt Brombeck is the Vice President of Sales at Business Information Group, also known as BIG, and has been deeply involved in the background screening industry for the better part of 25 years. In his role, Matt serves as BIG's subject matter expert on designing, implementing, and overseeing background screening programs for organizations operating in the insurance and finance space. Over the years, he has maintained positions on both the SILA and SILA Foundation boards and continues to be actively involved in several committees. Matt's a graduate of Grove City College and has been with BIG since 2005. Please join me in welcoming back to our virtual stage, Greg and Matt.
Thanks. I did not realize you'd be reading our full the credentials there. That's the end of our webinar. I think that's our time, Matt, right? It pretty much covered the entire hour. All right, so thank you everyone for joining. Matt and I are going to be going through all of the information gathered through this survey. I want to talk real quick about the survey. It was designed to obviously gather information from a whole bunch of different parties involved. Matt, if you could go to the about the survey slide, my apologies. And it's, as mentioned, this is the 5th iteration of this survey. So we've functionally as a task group been doing this, I guess to average it out about every 2 years for the course of about the last 10 years. It was sent to all the SILA member companies, so 30 some questions. The respondent rate was pretty good this time around as well. 112 unique responding parties. You see it, back in 2016, 2017, it was up as high as 166, 168. I believe that's more a result of consolidation within the industry than anything else, but still a lot of interesting information gathered from this. It was open from September 9th and closed on November 13th. Before we get into the responding questions, I do want to talk a little bit just about some of the common terms that we'll be going through in this for anyone that's not familiar with it. When we try to distinguish captive, employee, and exclusive type producer scenarios, that would be an individual who is a direct employee or an exclusive provider of those products. In other circumstances, we'll be mentioning broker, independent, or a contracted producer. Again, whether it's on the insurance or security side, these are non-exclusive individuals that sell or market products for one or more parties. So it's important to distinguish that as we go through. We did also, in trying to present this survey, we broke some of the questions down a little bit compared to previous times. So, we have slightly more respondents than last year. We did introduce several new questions that were gathered amongst the task group, and we also removed a handful of questions that historically the answers have been very consistent. We also did attempt in a couple of questions to distinguish between the practices across like licensed personnel, non-licensed personnel, captive, non-captive producers, as we just discussed, and specifically what we were considering HR versus other onboarding roles. There's certain scenarios, call center operators, for instance, they may be screened more on the HR side of the organization and less on the maybe not so much in the purview of the respondent population of the SILA membership. And a couple just quick notes that you'll see as we go through here. There's not a ton of overall movement in the base practices, but the credit report usage continues to decline amongst the responding population. We did notice civil record searches on the rise. And when we get to some of that, we'll talk about kind of where we think that's coming from. And also, finally, the 1033 waivers and the PDB, the NIPR PDB practices remain very mixed. There's no clear line about what some of the industry practices are. So, but yeah, let's get right into it. Section 1, a couple quick items on respondent demographics. The insurance carrier is the number one responding rate, responding population in this. So 112 answered, 112 of the 112 answered, and you can see on the last survey, the insurance carrier population was also the largest responding population. So the reason that's important is when we look at this data, when we see certain trends, we also need to think about, is it because of the nature of that organization and they're driving the overall trend versus you see a little bit further down at around 6.5%, the broker dealer population, how that may relate from securities and other factors. So some products and services may not apply as much, but overall, it was a very similar responding population to not just the last survey, but from a breakdown, but previous surveys before that as well. And the other question that everyone was asked before the logic started to kick in of whether or not they would be presented with some of the other questions is, does your entity conduct background checks on producers? Again, about 90%, and you can see 90% last time. It's always been in a very high margin. So there's usually about and true to form, a 10% fallout rate right from there, as far as the responding population. So knowing that gets us into the new producer screening. So these are going to be a series of questions. And Matt, if you're comfortable taking this section about what are the screening practices when discussing a new or prospective producer?
Yeah, so with the type of respondents in mind, heavy on the insurance carrier side of the house versus a broker dealer, we'll try to add some context and flavor to the actual data. So the first question is, who's really owning the initial process? And because the audience for SILA is largely the licensing and registration management teams, we have a heavy percentage here on that licensing and contracting areas versus HR, talent acquisition, which kind of speaks to the heavy influence of the independent distribution versus the captive and career agent populations. So this will help better understand kind of the context of the services that go into the packages and that sort of thing as we progress here. Does your entity conduct initial background checks and from a independent producer, high percentages, captive, once again high. A little bit lower, but the idea here is likely because this is really independent centric on the carrier front. So I think that's an understandable decrease there. Still, from an unlicensed perspective, not a lot of folks are doing it. I expect that to be, kind of the insurance agencies. You appoint or contract with the agent. Any of the support at the agency is going to be handled externally, from a carrier representation. So this is very much in line with what we would expect in terms of responses. This is a new question. All of our new questions will have an asterisk denoted by it. So we didn't have necessarily a previous versus current stats here, but this is all very much in line with what both Greg and I are seeing from an industry perspective. In general, when do you conduct the initial check? So these first couple of slides are all about who, what, when sort of idea. At the time of onboarding our contract, by far, the movement of the industry towards a just-in-time, sort of scenario, not doing it at the initial relationship with an IMO or a large broker, but more so, once the policy is in. That's when we're seeing the far majority, of the industry, and you can see a little bit from the last time around 2021, where it was slightly less than 60%. Now we're up to nearly 70% in that capacity. It just kind of shows where the industry is heading. Now, for these slides, the large body of it is going to be your current respondents statistics. We're going to have embedded previous responses, and then sometimes when there's an other, we're going to denote what other type of questions or comments may fall. Nothing really to pull out here except the differentiation between contracting versus an HR or an employee role falling outside of the licensing process.
Something else I was thinking too when I was seeing some of this data is there are some indicators where there's conclusions being drawn, like I believe this is how it's being done, but it's handled by HR. You see that HR is separate from department or a separate department from licensing. So there's a certain extent, and you may see that in some of the others where there's a maybe a belief, but again, the survey was sent to a specific individual at every single SILA company that was eligible to take this. So, again, based on size of organization, sometimes one department and the other department don't know the details of the other. So,
yeah, certainly a good point for sure. When running credit reports, what elements from that report is likely to impact an adverse decision for you? We see a lot of different elements here. A lot of it is public record in nature. Bankruptcies is at 62%. Civil and liens are at 60%. Now, of note, we did reference credit report in the actual question itself. It seems that a lot of respondents were really broadly defining financials as in terms of their responses. Civil liens, those are obviously not on credit reports any longer. Credit companies have removed a lot of that public record information, largely because it was not necessarily identifiable for identifiers. Current information was a challenge from the sources. But as we can see here, there is still a heavy reliance upon that public record knowledge. And that speaks to one of the earlier slides where we saw an uptick in the use of civil, and we'll talk about that in a moment, where that is still very much an importance. Now, from a broker-dealer perspective, those are obvious. Sorry if you hear sirens in the background, it's not for me. The disclosure issues that are necessary from a reporting perspective, that continues to be an important factor. that drives that. In the insurance carrier industry, we see a lot of organizations continuing to front commissions. And a big ticket item is, looking at things like disclosure issues, bankruptcies, liens, judgments. Now, the other high element here is the delinquency in collection accounts, overall debt. When we saw the removal of a lot of the public record information, we saw a lot of organizations looking at the credit reports in different lights. And, because the big ticket items are and have been removed, they're looking things like collections, past dues, past due amounts, but also frequency of those happening, which are all precursors to things like tax liens and judgments and bankruptcies. So we see a lot of the high items here as barometers for determining things like factors that need to be reported from a securities perspective, but also for those carriers that continue to front commission in their broker and agent populations, using the credit reports in a somewhat a different light than they have been in the past. Now, obviously, there's a few things that are called out here because credit is kind of a broad review. We see vector balances, which is the debt service, none of which is found on the credit reports themselves. See a lot of misdemeanor and felony responses, which don't necessarily fall on credit, but are certainly important from a violent crime control bill perspective. But you're seeing things excluded like student loans and medical. We've seen that happen, with some consistencies over the years. It's not just whether or not they have debt, it's the type of debt. Child support called out here. That's another element that organizations are looking at specifically. So, a lot of what we would expect, from a respondent's perspective, this is sort of new, so we don't have a lot of comparables, but certainly what, Greg and I would expect. Now,
and also, I do want to point out, Matt, that only 54 actually answered that question. So it's important to look at the answered versus skipped in these scenarios, whether it be the logic dictated that they skip it or just by practice that they're skipping it. But that is important. You'll see that when I was going through and kind of mining some of the data, it was whenever something, there's a couple questions you'll see where there's maybe only 25 or 30 respondents. The statistical relevancy of those percentages gets called into question a little bit. The higher we are, 50 plus, then it starts to have, I would say, more value, more that you can hang your hat on, so to speak, as far as okay, this does seem to indicate a practice versus this is just the time of day based on the number of people that responded.
Yeah, absolutely. Good point. Those numbers count for sure. So kind of the bulk of the program, what types of services do you incorporate as part of your screening reports? Our majority, we're focused on criminal, we're focused on regulatory sanctions. To Greg's point, a smaller subset incorporate credit reports. So that's why you saw a bit of the smaller numbers in the previous slide. The far majority, we're looking at county level research, federal level research. We're doing the social security trace, or address validation. One thing that's a bit surprising for me, from a statewide perspective, given the inconsistencies associated with statewides across the country, some offer it, some do not, some that do require you to jump through hoops. It's interesting, to see that so high on the list. The National Criminal Database has been growing over the years. We're seeing that percentage rise. And then as we sort of get a little bit smaller, we see some of the ancillary things, some surprising stuff like social media, which a lot of organizations do internally versus externally, but verification and review nonetheless. And we see vector popping up as we do on a couple of slides. this just expands it out.
Hold on. I'd like to go back, and I just want to point out the shameless product placement for Matt's organization's product and one of the other questions. I'm pretty sure Matt submitted that himself.
I may or
But
may not have,
yeah,
but
but
it's
yeah. So there is some shameless product placement there. But yeah,
I,
moving on to the comparison of to the last time.
thanks, appreciate that.
Yeah. I wasn't gonna let you off the hook on that one.
I like to gloss over that. This is the same current respondents, but in comparables to past. We see some lining up of stuff, where this time around both federal and county were in sync. The last time around a few years ago, county was certainly higher than federal. So we've seen that kind of level out. We saw statewide decrease a little bit. Credit reports decrease a little bit. So we're seeing minor shifts in what is going into the common packages, but the focus is kind of the meeting of the tune of the crime bill, the 1033, 1034, looking at criminal information, identifying felonies of dishonesty, breach of trust, validating terrorist watch lists and global sanctions and that sort of thing. And then minimally so some of these other elements that may apply from an employment perspective, a captive agent perspective. And great.
All right.
I think we'll move on to, we've gone through what folks do to mitigate risk on the front end. Now they're on board. What do we do? How do we do from there?
So this is an interesting question to me, and the sequence of data here that it's going to display, I also find interesting, and I do question whether or not the responding party is always fully aware of whether or not this is or is not being run. But as a general rule, it's like, okay, you have a producer, they're producing for you. You vetted them at the point where they onboarded. But what about after that? What happens after that? What happens if there's an event, a change in their history? How does that affect the business that they've sold, their ability to sell in the future? So this question was, obviously, do you run any kind of ongoing or periodic background checks on your existing producers? It's not, statistically that different than the response in 2021. Only about 40% are running, or at least are aware of the screening process on existing producers. However, and this is where I think that data is particularly when I talk about the number of answered. That previous question was answered by 82 individuals, and then you see. So this was basically those that selected yes, then got this question. So we're talking about when we look at these bar graphs, it is the statistical relevancy of the individual charts gets called into question, but generally, what are we looking at? If you're if you're running those checks, specifically, what is that frequency? The task group put together a handful of questions similar to years before, annually, every 2 years or more. Now, annually did creep up. A lot of the others went down. We had a whole host of other responses, and that was kind of listed out 7 years. It was requested by compliance. But the only decisive thing I think about this data set that we collected is that it's not very definitive. It's kind of all over the place. There could be post incidents or some other type of event, but generally speaking, 10 to 20% are running them based off of some type of trigger. It could be annually, every 2 years. And I do think there's some recent news, specifically out of California, with the Los Angeles court system somehow found, and I have a note, there's articles about it, if you want to look it up, but approximately 100,000 felonies between 1980 something and 2023 that were not reported to the California State Repository. So there's also a whole host of misdemeanors and some other information. So they're somewhat older records, but they are felonies, and they never reported to that state repository. The reason that's important is that state repository is what feeds the fingerprint process, which then feeds the licensing process. So arguably, there could be active producers that lived or have lived in Florida that were cleared to license, and then when they have to renew their license or submit some other type of fingerprint background check, all of a sudden something's going to come out of Los Angeles that wasn't there. Not because it didn't exist, it just didn't exist in the database that then fed to the other databases that did that. So a carrier would know that doing screening directly in that county, but that is important, just making sure you know the effects of the current population. I mean, I could go on for 20 minutes on that thing alone, but I won't. I'll just move to the next one for now. But I do want to mention why that's relevant, because the periodic screening does provide a level of insurance, pun intended, that someone is, hasn't had events post their onboard.
Mm-hmm. Yeah, which is why we come into the next slide about certain regulatory requirements and why FINRA likes to see routine and ongoing checks to reinforce the idea that you've done a concerted effort on the front end, you're meeting 3110E. Now make sure that person stays good, or if something is known, it's reported.
And I've heard logic arguments over the years on the carrier side where, they had to get printed to get licensed, and the state doesn't have specific language. These, I don't know, 12 states don't have specific language that is interpreted as being requiring to do some type of screening. So I just rely on that license portion. So again, there's blind spots that exist, and you do still have as an entity, a general responsibility when it comes to arguably. But okay, so the next question was, why do you run them?
When that individual wrongs somebody, they're not necessarily going to be suing the state. They're going to be suing the carrier, the agency. So there's certainly some skin in the game, in terms of that. Sorry, Greg, I didn't want to talk over you.
No apologies necessary at all. But again, why do you run a company policy? And company policy can be very broad. Company policy can be in place to basically comply with an interpretation of a regulatory requirement. So this question was a newer question. We were maybe trying to figure out how to ask it and how to collect information that might be relevant. And you see some other responses on carrier required. So personally, I think that we may need to maybe revisit, this question and how we frame it out to get a little bit more concrete data, because I think most company policies are, built around a fundamental concept of regulatory and other guidance, just expanded from there. So, but the next question that we asked along this, existing producer screening was, what types of services and searches do you run in those periodic backgrounds? This one was interesting. It was a new question. Predictably, we saw, a drop off in the things that arguably wouldn't change. So there's not a lot in the way of employment or education verifications, things like that. If it was valid when they were onboarded, it's valid when they're still present. The county criminal and federal criminal still lead the way. It's statewide still runs in there. There's more shameless product placement by Matt's organization and the one other response. I'm just going to point that out again. But again, you're talking about SSN validation, PDB with its license history and regulatory inputs, or actions would show up within that. Direct searches of regulatory and prohibited party databases, credit. So the stuff that theoretically could change, and in hindsight, well, at least from my personal experience with some organizations, usually the periodic check is a little less. You're not running 7 years of address history and then running those jurisdictions for criminal history, because you're mostly looking at maybe current residents. So sometimes it's a streamlined version. It's a slimmed down version if they're going to do a type of periodic screening. So if your initial screen costs X, your your periodic every 2 years type screening would cost maybe 50% of that, just because you're looking more at current stuff. Um, but I did find it interesting. I also thought it was interesting to put the pre-hire side. Yeah, matter of fact, if you can go to the next one, the pre-hire practices. That was a slide that Matt had gone over, paired side by side with the post-hire practices. Again, we're only talking about 29 respondents in this post-hire, but still the trend is fairly consistent, and you can see where the drop-off areas were, and what the core items are. So it makes a lot of sense, aligns with the reality that I exist in. So wasn't shocked by it. Was more just pleased to see that it aligned with my own experiences.
All right, so
Yeah,
moving
so
on.
now 1033 waivers. So everybody knows everything about these. So this should be a quick one, right, Matt? No.
Incidentally, there was a lot of respondents of I do not know what a 1033 waiver is.
Mhm.
So, yeah, I spoke earlier, the Violent Crime Control and Enforcement Act of 94, it's section 1033 that requires that you can't do the business of insurance with somebody that has a felony of dishonesty or breach of trust. Somebody that's been nabbed, caught, has a felony, um, they can get out of jail, and they can file a waiver with states, and the state can say, "Yep, that securities fraud was a long time ago. You've righted your wrong, and I'll go ahead and give you that license." Yeah, so there's a whole process built around giving the individual another opportunity, if you will. About half of the respondents answered, and by a pretty wide margin. So the question you ask about 1033s on producers during the onboarding process, the far majority, 2/3 of the audience here, do not even ask about it. And that's a big change from still a big population that doesn't know what 1033 is, but it's a wider shift from previous in 2021, where fewer folks are asking about it. And of those, what's the level of consideration you're giving to those waivers? The idea that somebody may have murdered somebody, and now they got their license, and whether or not you want to appoint them and contract with them anyway, this kind of speaks to, it says moderately impact is the highest. It'll likely be based on individual scenarios. That's still the highest from what the reportability was back in 21. So very little shifting. And it kind of just speaks to me that, again, this is a small subset of the respondents. Only 29 have answered, and largely, going to be based, off of the situational of what had happened with that particular individual.
Matt, we have a question too, and I think we can tackle the. I mean, we are getting a little tight on time given what's left, but I think it's relevant to the 1033 conversation. What if the resident state Department of Insurance did not issue out a 1033 waiver on a non-resident requires one? How can someone work around that issue? So there's a larger concept here of, quite frankly, any carrier, just because someone has a 1033 waiver does not mean that you have to accept that waiver as an individual carrier. It permitted them to get licensed in that state. But when the resident state Department of Insurance did not issue a 1033 waiver, but a non-resident state requires one, it can be very complicated, because some states are issue them very, very infrequently, and I'm not sure about what exactly that workaround may be. That may be more of a particularly nuanced question, but just acknowledging that the 1033 waiver is both, it's issued at the licensing phase, but you are not required as a carrier to accept it. And then also, one state does not have to honor another state's DOI waiver. It can get particularly problematic.
Yeah, and that's a question that I know goes around the room and around the country.
Hmm.
tables at the SILA conferences each fall. Invariably, those are questions around why one state accepts this and doesn't accept that, and it's a really important to attend those conferences because you get that dialogue with the states on these very particular and unique instances that simply don't come up with any level of frequency. All right, so you kind of talked about the who, what, when
Yeah.
of the checks. So we did the check. Now, what are we doing to eliminate or deny?
Yeah, so the elimination factors here, it's pretty there's some interesting data here, and the way we plan some of this out is actually pretty neat for someone at least like me that likes some of this stuff. But as far as what percentage are eliminated due to background check results, less than 1% is still the very the leading factor. I wouldn't expect that to change. You are talking about generally a pre-screened population being they were pre-screened to get licensed to even start the process. So there's a pre-vetting that goes on long before an individual producer is directly affiliated or associated with your entity and brand. So I don't expect that number to change, nor would I expect that trending to change. I don't, it's very rare that I see, 5%, elimination rates based on, at least particularly on the criminal side of things, but just in background checks in general. The next question, though, is we wanted to try to, we introduced as a task group a way to, we wanted to kind of rank from 1 to 4, 1 being the most common reason you would eliminate a candidate due to the background check results, and 4 being the least. The reason for this graph and this data was, yes, the background check is it's a larger item, but specifically, what are the factors within that background check that are generally the eliminating factors? If I could draw your attention actually to the graph on the right, that's the actual scorecard. So basically, if you take all 4 of those different options, credit versus criminal versus regulatory action versus other, criminal history had the highest scorecard rating, meaning that was the most common factor as an eliminator at 3.52, followed by regulatory actions, followed by credit, followed by other. So if you're just applying like just the score factor, the value of the responses versus the rate of the response, that would be the overall impact card. And you could see kind of where it breaks down though back on that kind of the bar charts on the left, where the individuals ranked and the item is the number 1 reason for eliminating. 44 of those were criminal history versus 2 of them were credit versus 25 of them were regulatory and 0 were other. So that 44 led to that 3.52 scorecard. And then it broke down differently as expected, quite frankly. Regulatory was the second most common event at 38 times. That was ranked as number 2 out of the responding population. And then all the way down the others, though. The others were particularly interesting. If you look in the others, which was Matt, the next slide, that there's a lot of content here. What are the reasons you would eliminate an individual from from the process? There's things completely unrelated to the background check, so customer complaints, debit balances, failure to disclose information. That's always a big one because sometimes it's not the history itself; it's the failure to disclose it versus when it returns, and putting those 2 items against one another obviously creates a trust factor. But there's a whole bunch of options across there. There is not any shameless product placement for Matt's organization here. I do want to point that out. But a lot of other responses. Nothing showed up, in at least in a verbatim category, more than once, other than NA. So I did find that very interesting, and I'm curious to see how that continues to play out. We asked a similar question, as far as excluding the crimes associated with Section 1033, which is what Matt had mentioned, the felonies involving dishonesty, breach of trust. How far back do you consider criminal history relevant to a producer's suitability for a position? So this is specific to criminal history, and trying to put this in a way that visually made sense. We went back and forth on a couple different ways, but this is basically where we landed. If you look at felony convictions, so 78% of the time, any history involving felony convictions was a particularly relevant factor versus you look at misdemeanors, for instance. Misdemeanors are kind of scattered across, or any history involving that versus you look at misdemeanors. Misdemeanors is far more in the 49.5% of events that occur within the last 7 years is more relevant. So this didn't tell me anything that I found shocking. I mean, there's some nuance here, but generally speaking, if you're looking for felony convictions, what's the most common practice? Any history regarding it when it's occurred is it would be the most common practice. Though in some cases, some organizations are only really concerned with felonies that occurred within the last 7 years. In a smaller sliver, that 4.35% is concerned with felonies within the last 10 years. Misdemeanors, the largest percentage, as I mentioned, 49. So almost 50% of the responding population is concerned with misdemeanors that took place within the last 7 years. The non-convictions one is a little bit interesting to me because within non-convictions, the events that occur within the last 7 years, quite frankly, under the Fair Credit Reporting Act, non-convictions beyond 7 years wouldn't be reportable anyway. So any history, regardless of when it occurred on a non-conviction, is that 30.65 is kind of, it doesn't really align with at least the stuff that I would see. On the pending and open cases, that's a different story. And the general argument is that a pending case is active as of today. So, as when it occurred versus is it still pending are kind of two different conversations. But this was the first time the task group tried to collect this information. So we really tried to figure out a way to present it in a way, present a fairly complex variable system in a way that might be consumable. So if you get a copy of the slide deck afterwards, I recommend reading it, thinking about it, and going back again, making sure it makes sense. But this was our best attempt to present this.
Yeah, the only thing that really stuck out at me was that felony convictions, where there's over 21% or so that, if that felony happened 8 years ago, folks aren't concerned about it. And the 1033 doesn't have any time frame stipulations. So as you kind of review this against your own policy and kind of kick the tires and stuff. That would be one area that I'd want to maybe call out from an analysis perspective is there's really no timing associated with 1033. There's no timing associated with the FINRA rules. For those that are in the banking side of the house, the public law doesn't have any limitations. The FDIC doesn't have any limitations. So certainly something to consider, as you're reviewing and kicking the tires on your policy.
No, there were quite a few other responses, and many of those other responses are non-convictions aren't considered. Non-convictions probably wouldn't be considered. So, I mean, there's definitely a trend in here. With this being the first time that we've asked the question, that's kind of why the task group puts this stuff out there to try to, determine what the practices are and figure out how to present it, and then figure out if that answer makes sense, or maybe how we can reframe it again in the future. But I would take that entire group here, and just kind of compare it against the practices and see where it lines out within your organization. That's what I would do in that position. And then the next one was, do you provide? So we've always asked questions about pre-averse and adverse action, things like that. They're all Fair Credit Reporting Act required items. But do you provide candidates with a pre-adverse or the initial adverse action notice at the and a chance to dispute the results of the background check? Pretty consistent, as far as it. Yes has always been the predominant answer. However, it did drop quite a bit here. So you see in the past it was 75%, where we didn't hit 70% on this. Just as a general guideline. I would advise any organization, if you're running background checks through, an entity like mine or Matt's or anybody else's,
And
and
IPR.
yeah, and if you're running a PDB and you're getting negative information back from NIPR about regulatory events or other items, of that stuff is all subject to the Fair Credit Reporting Act under most interpretations that I've ever read. So, and if it's subject to the Fair Credit Reporting Act, then therefore some type of adverse action is also necessary. The next question was related to that. Do you provide the final adverse action? And again, 70%, but still a little bit shy of the response rate back in 2021. So, in a perfect world, this is 95% response rate. Maybe some organizations aren't quite sure. It's handled within a different, part of the organization. But these are things where I don't believe it to be fully accurate to at least what I see in my communications. I believe the actual rate is higher, but just based on the respondent population, there's some nuance to the adverse action that I think it would be in everyone's best interest to make sure your organization's familiar with that.
Indeed.
The next question, how long do you wait between sending the pre-adverse and adverse action? So again, we're talking about a smaller population, only 45 were brave enough to answer this question, but the response numbers are pretty consistent with previous years. Usually it's just for clarification, the FCRA is not specific. It just says you have to wait a reasonable period of time. Case law has dictated that 5 days is not reasonable. 5 business days is the minimum for reasonable. There are several individual state laws that have passed that have extended some of those timelines to 7 and 10. So generally, anywhere between 5 and 10 would be my expectation. That's kind of where the numbers line up. Some are doing more than 10, and then a host of other scenarios. So, and again, it's handled by compliance. It's handled by a different department of HR. So, the timing, all that information, including the other responses, is very valuable in kind of gauging and framing out how this looks both today and in the future. So, thank you to everyone that was kind enough to respond to that. There's also a methodology question on this. How are you sending those adverse action notices? Is it email only? Is it standard U.S. mail? I still see certified overnight. I'm surprised that number still exists even in that at that percentage. U.S. mail only. And then other, again, a lot of individuals that are not sure. So if you take some of the others out, it obviously would reshift the remaining response rate. But overall, it's either email or it's email and U.S. mail. I just see more and more email or some kind of an email to a secure portal or something. You don't want to create a barrier to the individual getting access to that. But in most cases, communications with employees, consumers, producers, whatever you want to call them at this phase, it had been email up to that point, so why not continue on that email track? I haven't seen anything that says not to do it. So,
yeah, agreed.
And yeah, that was and now, Matt, we're moving into the NIPR section. Just on a time check, we got about 10 minutes, so I don't know how if you just want to talk fast or what the play is here. That's up to you. So.
Yeah, we'll certainly move through this section relative rapidly. So in terms of NIPR, a far majority of the respondents were insurance carriers, and so there was an expectation that a far majority would have responded to this, and a high majority is using PDB and NIPR. So obviously, licensure and sanctions, insurance sanctions are key elements in an onboarding process. This is where the conversation around FCRA, the PDB is an FCRA compliant tool. It says so upon entry. There is an expectation that if you're using that information, you have to have authorization, and you have to follow the FCRA path in terms of pre-adverse and adverse action. So that's a big key element. So we're seeing very similar numbers. Not a huge change from 21, but something to keep an eye on. Greg mentioned about pre-adverse and adverse action. Certainly a suggested path forward and this is keenly falling, on the PDP polls and IPR stuff. This reflects, are you sending an initial action, giving them an opportunity to dispute? Still 63 folks answered, but we're seeing a far majority of those are not necessarily following the FCRA standards that have been laid out. Now, this is a bit higher, than the 52% that it was back in 21. So it's a little concerning that even less folks are adhering to, predetermined standards. But as you're kicking the tires of your program, do look at that process. Where you're going to sources directly, FINRA, the broker check. If you're going to the FTC, doing an OFAC check, if you're walking into a courthouse, no FCRA, you're doing it yourself, it doesn't apply. But as soon as you're using a consumer reporting agency, as soon as you're getting public information from a repository that is FCRA compliant, i.e. Applicant Insight, BIG, and IPR, it applies. So definitely keep an eye on that. In the adverse process, very much in line with what we saw back in 21, still heavy on the nose. So take a look at that, as you do your analysis. We've talked a lot about the FCRA and state specific things throughout the conversation today. We have a couple of questions that are targeted specifically to that. Does your process include state specific disclosures? And far majority yeses, which are great. And again, we're heavy on the independent side versus the employment population, but we're still seeing a lot more yeses than nos, and we would expect that. Beyond the FCRA, there's state laws that and often referred to as local laws that things like ban the box initiatives. In individuals past having a right to be forgotten, giving the individual additional rights on the local levels, Illinois, California, Los Angeles, New York. There's a lot of jurisdictions that require that you have to provide additional and very clear guidance to the individual as to why you're denying. So always look at that in your lens as you're reviewing your policies and procedures. Does your process include ban the box, fair chance disclosures, and adverse action content? Very much in the same line. We only had about half of the folks kind of respond. In our industry, the FCRA largely hasn't changed. Violent crime bill has not changed. But what has changed is your abilities to use information in a negative impact to an individual's onboard. And so you have to take into consideration what some of these local laws drive, giving the benefit of the doubt of the subject. And many of these go beyond what the FCRA says, in which you simply give them notice. Hey, here's a background check. We intend to not appoint you because of it. Versus, here's the background check. Within that background check, you have a crime, and because of this crime, we are denying you. So that specificity really comes down to these fair chance ban the box disclosures, both on the front end as well as making an adverse decision. And you have different processes built in to facilitate that. The local laws are growing, and this has been growing in recent years. So I would expect organizations to be growing their policies. I expect this to still be a bit on the no side. It is getting lesser, so we are seeing the movement and the shift in the right direction. And now on to that final decision making.
Yeah, just a couple questions here on decision making. What department or unit in your entity reviews or adjudicates the majority of those background results on licensed producers? The licensing contracting continues to be number one as expected. Not a ton of change. Compliance and legal is still involved in the process. And then and again, this is the initial. So we're talking about who's evaluating just that initial search. We do have a follow-up question to this, which is the next question is what department or unit in your organization reviews the escalated ones? So the ones where like, okay, we've got some information you're not quite sure. Again, compliance and legal is the leading factor. Licensing contracting is second. Again, not dissimilar to previous responses. So wasn't expecting a ton of change here, but but over time, sometimes those roles do change. So it's important to continue to ask that question. And then the last, core question in this is, does your entity have a defined appeal process for disputed results and decisions? So, which also ties a little bit to, there's a question in the chat about the PDB results, and if you verify it through the state site specifically after that, does the FCRA still apply? So, first off, the question here is, does the entity have a defined appeal process for disputes? Most organizations should. The FCRA has a baked-in dispute and reinvestigation process, but ultimately, if your organization still decides not to move forward with the producer, do you have a process in place where if they want to dispute that decision, 50% of that, of a total of 58 respondents, replied that yes, they do. That is notably less percentage-wise than the last time we asked that question. So that was a little I guess peculiar to me. Could just be the who was responding, what organizations were represented, but getting to that question about just the PDB and does the FCRA still apply? The moment you run a transaction and get the PDB result, the FCRA was applied because the NIPR, unlike FINRA, is not a government entity, so they're compiling all this information from individual states and presenting it to you. So the moment you've got that and considered that information adverse, the argument is, and the language on NIPR site, states that it's a consumer report and thus the different, events apply. So it would be advisable if you're going to eliminate someone based off of NIPR results, regardless of whether or not you verified it directly with the source state, it would be advisable to consider treating that as a pre-averse and adverse action FCRA event.
And just to add to that, the agent does have rights under the Fair Credit Reporting Act. So that individual can go to NIPR and say, I would like a copy of the consumer report that was provided to such and such an entity. And that individual has rights to receive it. So you can't necessarily go to different sources and say, oh, but I used it over here. I didn't use the information from the PDB. Ultimately, it's going to be provided, to the subject. Transparent.
Yeah, I mean, when it comes to that type of litigation, it's all very there's other industries that are far easier targets. It's an uphill battle, with some of that stuff within insurance and securities, but it's definitely out there. There was we call it a bonus question. It was more just what would you like us, to consider in the future? And it's the very last one. There's a couple points on here, survey results and recommended best practices. What is the best practice for periodic background investigations? Do most carriers ask questions up front in the appointment process or rely on it? Quite frankly, I could probably do a session just on these questions alone and the variables that play in there. But I do really want to thank the task group for everything that they put into this to make this survey work. I want to thank Matt for agreeing to present the information with me and for being along for this ride that we've been on with this task group, and everyone that responded. We wouldn't be able to present any of this information if you weren't willing to share it. Nothing's definitive, nothing's conclusive in this information, but I think there's a lot of data here that can help make informed decisions, and that's really what this stuff's all about. So I want to thank everyone that was a part of this. Matt and I were just the figureheads for the presentation layer.
Well, I'll tell you, Greg did a ton of work in pulling everything together. So I'd be remiss without thanking him for taking the heavy lift that he has and leading the task group for as long as he has. We're always open to new ideas and new folks joining that task group. So if you'd like to join, if you have some different ideas, if you have some questions, if you have some topics to discuss. We don't meet every single month. Most of the time we try to. So please, reach out to us. We're open, and it's just free dialogue. There's no judgment. There's no no question that's wrong. So certainly join.
And for anyone that's interested in that California thing, if you just look up Los Angeles County unreported criminal convictions, if you just Google that, you'll find like 10 different articles. Any article I find, if I put it in the link, it'll try to ask you to pay for a subscription to Los Angeles Times or some nonsense. So, yeah.
Did we catch all of the questions from the chat?
Tried to. It was a lot of content, a lot of questions. We went over the hour. Apologies for anyone that was hoping to get 15 minutes back of their day at some point in this, but I hope you enjoyed it.
No, I think you guys did get everything. I want to thank you both so much for providing us with all of this information. We appreciate both of you, and thank you also for being such good friends to SILA and the SILA Foundation. We hope to see everyone at our second webinar this month. Pause, Plans, and Peace of Mind, Pet Insurance Explained. Remember that our webinars are public and free of charge, and we love it when you share the invitations. Watch for and complete our post-webinar survey, and we hope to see you next week.
Thanks, everybody.
Thank you.